My name's Kate Akerman, and the subject of this presentation is the decision of the Divisional Court in the well-publicised case of Bell and Tavistock. The claim in the case was for judicial review of the practice of the defendant NHS Trust through its Gender Identity Development Service of prescribing puberty-blocking drugs to persons under the age of 18 who experience gender dysphoria. The question for the court was, can children and young persons under the age of 18 provide informed consent to the prescription of puberty-blocking drugs, and if so, in what circumstances? Gender dysphoria is a condition whereby a person experiences distress because of a mismatch between their perceived identity and their birth sex. Persons with gender dysphoria may be referred through the NHS for a range of medical interventions. There is 3 stages which are recognised. Stage 1 is the administration of hormone or puberty blocking drugs. These suppress the physical developments that would otherwise occur during puberty. The effects of puberty blockers are said to be reversible. Stage 2 is the administration of cross-sex hormones. These can only be prescribed from around the age of 16. And cross-sex hormones are to a very significant degree not reversible. Stage 3 is gender reassignment, only available via adult services to people aged over 18. Stage 1 puberty blockers can be prescribed through the NHS for gender dysphoria to children as young as 10. It's the practice of the development service to require the informed consent of a young person to whom puberty blockers are prescribed. Who are the parties in this case? Well, the claimants are Kira Bell and Mrs. A. Kira Bell was born female and describes an account of her journey to a diagnosis of gender dysphoria. When at 15, she was referred to the Gender Identity Development Service. At 16, she was prescribed puberty blockers, and at 17, she commenced testosterone. At the age of 20, she underwent a double mastectomy. However, in her 20s, she began to realise that the vision she had in her teens of being male did not fit with her reality. She's since stopped taking testosterone and now wishes to identify as a woman. She says she feels she made a brash decision as a teenager and regrets the irreversible physical, mental and legal changes she went through. The defendant is the Tavistock and Portman NHS Trust, one of only a handful of NHS trusts to whom the Gender Identity Development Service may refer a child or young person for assessment by a clinician with a view to possible medical intervention. The defendant asserts that Kira Bell was Gillick competent and was provided with the fullest information after a large number of consultations. So what were the competing arguments? Well, the claimant's case was that children and young persons under 18 are simply not competent to give consent to the administration of puberty-blocking drugs. They say that information given to those under age 18 by the Tavistock is both misleading and insufficient to ensure that they are in fact able to give informed consent. The absence of procedural safeguards and inadequacy of the information provided, they say, results in an infringement of the rights of children and young persons under Article 8 of the European Convention for the Protection of Human Rights and Fundamental Freedoms. In the circumstances, the claimants say the court should be guided by the approach of the Court of Protection in its practice guidance, which deals with serious medical treatment and which sets out those decisions relating to medical treatment where an application should be made to the Court of Protection for a best interests decision. The defendant's and the intervener's case was that the process in the NHS for taking informed consent from a child under the age of 16 is lawful, compliant as it is with Gillick principles. In respect of 16 to 18-year-olds, They say if the patient, the parents and the clinicians are all agreed, then the court simply has no jurisdiction. They say that the child or young person only needs to understand and consent to puberty blocking treatment. And an understanding of and consent to stage 2 cross-sex hormones is simply not required. And finally, they say that where a child with gender dysphoria has reached the endocrine clinic, there is no alternative treatment option other than puberty blockers to alleviate the patient's distress. So how did the court approach the issues? Well, the court took the view that it was appropriate to consider, firstly, whether a child under 16 or a young person between 16 and 18 can give the requisite consent. And secondly, if in principle they can, whether the information provided by the NHS is adequate for achieving informed consent. And the court considered the evidence base relied upon by the defendant and the interveners in their use of puberty blockers, in particular as to the use of puberty blockers, their impact on patients in the short and long term, and on the efficacy of their use. And the court's survey of the evidence and summary of the evidence in this case, in the judgment, gives a real flavour of its view as to the lack of qualitative, longitudinal, robust, peer-reviewed research about puberty blockers, and in particular as to their experimental nature, the wider and potentially adverse impact of puberty blockers, and the strong correlation between stage 1 treatment, puberty blockers, and stage 2 treatment, cross-sex hormones. I'm going to hand over now to Sasha Watkinson, who's going to deal with the next part of this presentation.
Hello, my name is Sasha Watkinson and I'm going to talk to you about the decision in this case. As you know, the court received evidence in relation to puberty blockers, stage 1 of the process, and also cross-sex hormones, stage 2 of the process. The defendants had argued that in determining whether a child or young person could give informed consent to the treatment of puberty blockers, that part of the treatment, stage 1, should be viewed independently. The divisional court rejected this view and concluded that because the vast majority of children and young people move on to stage 2, and because stage 1 and stage 2 are part of the same clinical pathway, that it was wrong for the issue of informed consent simply to be restricted to information about puberty blockers. The court therefore considered that in order to be able to give informed consent, a child or young person would need to be informed about both puberty blockers and also cross-sex hormones. The information that a child or young person would have to be given, that they would have to be able to retain, understand and weigh up in order to have the requisite competence in relation to puberty blockers, were the immediate consequences, both physically and psychologically, to inform a young person that starting on puberty blockers, the chances are that they would move on to take cross-sex hormones. The relationship between cross-sex hormones and subsequent surgery and the risks that come with that cross-sex hormones may well lead to a loss of fertility, may well have an impact on sexual function. And also, and I think quite importantly, the unknown physical consequences of taking puberty blockers, so informing the child or young person of the known and the unknown. And on that theme, the fact that actually the evidence base is highly uncertain in relation to this treatment. So a much broader ambit of information for a child or young person to be given, and also far more risks to be outlined, and for a child or young person to reflect on and to be able to show that they have absorbed and understood. One thing which clearly troubled the court was the lack of evidence of the efficacy of puberty blockers as a treatment for gender dysphoria, and also the long-term outcomes of taking puberty blockers. The court had significant concerns about that, and also it didn't see that a remedy to the problems it had identified was to arm the child or young person with more and more and more information. The court highlighted that it may be that whatever the information given to a child or young person, they would simply be unable to identify the long-term consequences and weigh up the implications of treatment to the appropriate standard in order to be able to give the informed consent that they needed to. So in terms of headlines, in terms of the key decision by the court, well, for a child 13 and under, the court didn't beat around the bush. It concluded that a child 13 or under is highly unlikely to ever be GILIC competent. 14 and 15-year-olds, well, they fare a little better. The court is only very doubtful that they would be able to understand the long-term risks and consequences of a treatment with puberty blockers. The court accepted that the more mature the child, the increasing likelihood that they would be able to provide informed consent, but that is as far as the court was prepared to go. Now, looking at the role of the court after this judgment, the court did see a role for itself, unsurprisingly given its judgment, that clinicians may well consider it appropriate to apply to the court if it's considering offering treatment of puberty blockers or cross-sex hormones. And the court, in terms of expressing its view of how seriously it views this treatment, it said this: that perhaps apart from life-saving treatment, there will be no more profound medical decisions for children than whether to start on the treatment pathway. So bearing in mind, we know that life-saving treatment and decisions as to whether that should be given, not given, whether it should be withdrawn, those are all matters that routinely come before the High Court. And it is clear to me that from this decision of the Divisional Court, that the Divisional Court sees a role for the court in identifying the best interests for children for whom this treatment is being considered. The other question that the court was asked to determine was whether in fact the Tavistock and other health trusts who'd intervened had given sufficient information for children and young people to be able to give informed consent. Now, I've already touched upon this because we know that the court reached the view that actually it wasn't a case of provide the information and the child will be enabled to become GILIC competent. And in fact, the court was critical of the Tavistock Clinic because it expressly rejected the assumption, as it labelled it, that the Tavistock Clinic made, that if a child is given information which is discussed with them sufficiently often, then they will be able to achieve GILIC competency. That assumption is incorrect in the view of the Divisional Court. So actually, the second question is really an academic one, because when answering the first question as to whether a child under 16 or 16 to 18 could be GILIC competent, the court was clear that in fact the breadth of information that a child or young person needed to receive and the lifelong impact of such treatment for them to reflect upon, that it may be, and we know from age 13 and under, 14, 15, that the court thought it was highly unlikely that any of those teenagers would be able to provide informed consent. So that second question, less important by the time that the court had reached it. Now, we know that the Tavistock Clinic has suspended its endocrine treatment pending the Court of Appeal decision, which the hearing is going to be the end of June. And so at some point in July, hopefully we'll receive a decision from the Court of Appeal on the issues that they are determining. It will be a fascinating judgment. In addition to this presentation, Kate Akerman and I have also prepared a paper which you can access, which sets out in more detail the issues that we have both touched upon. We hope that's useful, and we look forward to updating you after the Court of Appeal decision.